number 115972, State of Kansas v. Warren.
May it please the Court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Cedric Warren. May I please have 4 minutes for rebuttal?
4 minutes is granted.
Mr. Warren was originally sentenced to the hard 50 along with 2 concurrent 150-month prison terms. This court reversed the hard 50 under a lien, remanded for resentencing. On remand, the state did not pursue the hard 50 and instead asked the court to impose everything consecutively, changing the original non-grid sentences from concurrent to consecutive. And in what I'm not really sure how it happened, because Morningstar was brought up below, everyone said apparently that the state represented that Morningstar said that the court had the authority to change the non-grid sentences. And the district court ultimately sentenced as the state asked. On appeal, Mr. Warren argues that the district court had no power to resentence him on the non-grid sentences. And it appears that the state concedes that with respect to that the changes to the on-grid sentences are actually controlled by Guder and Morningstar. So what do they say? In short, Guder and Morningstar both synthesized together say unless the primary conviction is vacated or a new crime somehow becomes the new primary conviction, the district court cannot on remand modify otherwise legally imposed sentences. In this case, the primary crime was not changed in any way. Thus, the district court had no legal authority to change things from concurrent to consecutive. The state first argued Guder and Morningstar were wrongly decided, then argued that even if they were correctly decided, the off-grid could be ordered to run consecutive to the on-grid sentences. And I was going to plan to address both of those issues the way the state brought them up. With respect to Guder and Morningstar, the state begins by claiming that stare decisis should not apply because adhering to it would cause more harm than good. I think that if we first and foremost look at the basis for Guder and its progeny, that the amendments to the sentencing statute, specifically the 214603 authority to modify, granting the ability to modify sentences, the removal of that authority drastically limited the district court's ability to modify lawfully imposed sentences. So what the state is arguing is that our 20 plus years of authority on that should go out the window, which is basically what that's going to lead to. And I would also point to Anthony, because I think that if this court goes the state's way, then Anthony, which was when this court said that the motion to modify is no longer available for felony DUIs, based upon the changes at the time of the guidelines. Anthony basically goes out the window. You have to overrule Anthony because there is nothing saying that you can't modify a DUI or other non-grid sentence. So that's going to be opening up a whole new can of worms there too. But frankly, I also wanted to add one more point to this. I'm not sure the district court gave it much consideration because I think it didn't think about its power on this, but I'm pretty sure they probably shouldn't have even there was departure motions below, and I'm pretty sure that those shouldn't have been before the court also, in light of the fact that those non-grid sentences weren't up for grabs, so to speak. Nevertheless, if we look at stare decisis, the rules of this court have said that in a situation where the legislature can take action following one of this court's decisions, stare decisis is particularly compelling when the legislature doesn't act. And Gooder and Morningstar have both been around for about 5 years, and there's been no legislative change. In that, because of that, this is the exact type of situation where stare decisis should be upheld. Another kind of unintended consequence here for the state, if the state were to have its way in this particular case, the state may be forgetting that this can go both ways. Formerly consecutive sentences could be all opened up to become concurrent sentences. And it would open up the doors to departure sentences for sentences that were otherwise final and legally imposed. So this is, again, kind of a Pandora's box the state's trying to open in asking for Gooder and Morningstar to be overruled. It seems without authority, the state claims that the guidelines did not alter Woodbury, but I think this court has directly held otherwise. But looking at Woodbury, first, Woodbury itself is not really on very solid footing. It cites to Beck to say that a sentence all has to be pronounced in sentences are all kind of a global situation. But that's not what Beck was about at all. Beck was a situation where the defendant was sentenced in a multi-count case in only one of those counts for whatever reason. And I don't know why 100 years ago they did this, but they did, and ultimately the governor pardoned the defendant on that particular sentence. The state then tried to bring the defendant back in to have him sentenced as to the other counts, and the Beck court said no. The day of sentencing is the only day of sentencing. You don't get to come back later. So that wasn't something saying that consecutive and concurrent sentencing is a global thing, and if one particular sentence gets reversed, you get to go back on all of them. If anything, it kind of points the other direction. But nevertheless, Woodbury applied to an indeterminate scheme, changed by the guidelines, and the old indeterminate sentences did have statutory facts that were to be considered when considering a global sentence, and that's 214606B. That's all changed. The guidelines are only supposed to consider the severity of the crime, and that's in the old 214702, and the RECOD, it's 6802. Only supposed to be considering the severity level of the crime and criminal history. It's not a situation where you consider all the old facts that you did under the sentencing guidelines. But perhaps most importantly, the pre-sentencing guideline schemes all allowed for modification of sentence. As far back as 1886, a court could modify sentence as long as it was still in the district court's term. Subsequently, we had explicit statutory authority. I think that was in 1965 when that came into being. So Woodbury just isn't applicable to the modern era of the sentencing guidelines, given the fact that the legislature specifically removed the authority to modify sentences. The state claims that Snow addressed the continuing viability of Woodbury. All Snow did was cite Woodbury. Gooder was the first case that actually analyzed the viability of Woodbury. So I'm not sure, I don't think that Snow provides the court with any sort of guidance. Next, the state points to Senate Bill 488, saying it somehow evinces a legislative intent that the punishment fit the crime, and both parties presented the legislative history behind that. Nowhere is any such intent mentioned. The only intent behind that was to clarify a potentially ambiguous situation, and that actual ambiguity existed because of the revocation of the district court's power to modify a legal sentence. That ambiguity existed basically because the changes to 4603. So the state's legislative history argument holds no water. Finally, as to Setzer, in Setzer, which the state seems to rely quite a bit about, the United States Supreme Court was trying to determine whether or not statutory authority limited a federal district court's power to run a federal sentence consecutive to a non-existent sentence in another jurisdiction, or whether basically the government's argument was that the Bureau of Prisons had that authority. They would decide it later. And in Setzer, the court went from a position of, well, it's traditionally always been in the power of the courts to do consecutive and concurrent sentences. The statute at issue 18 U.S.C. 3584 only withheld sentencing authority in limited circumstances, and therefore it was only addressing those, and therefore that pre-existing common law authority still existed.
Could you move on to you're almost out of time, and I'm curious about your argument. Really, it's kind of a second issue here, and that is the modification of the off-grid sentence to run consecutive to the on-grid sentence. As I understand it, originally the sentence imposed was a hard 50, and then the on-grid sentences were all to run concurrent with that hard 50. Is that correct?
Correct.
And your argument is that somehow the statute precludes a imposition of a consecutive sentence?
Yeah.
Could you explain that? I'm looking at your brief. I'm not quite certain how they conflict. And then I want you to speak to, was it a modification to change the on-grid sentences to run consecutive, to run consecutive as opposed to concurrent, if I'm making sense? Address your legal argument, but was that a modification, and what should we do with it if it was a modification?
Okay. With respect, and I understand it's a little bit confusing on the argument with respect to 4720B2.
Yeah.
What 214720B2 says is, if sentences for off-grid and on-grid sentences are ordered to run consecutively, the offender shall not serve the on-grid sentence until paroled from the off-grid sentence.
Right.
So let's think about that logically. You cannot serve, if you have to serve your on-grid sentences after your off-grid sentences, you cannot run an off-grid consecutive to an on-grid. Because by definition, the off-grid would be starting, if it was consecutive to the on-grid, the off-grid would be starting after the on-grid. And the statute specifically addresses this.
Is that what the court did here?
Now, well, that's what the state's argument is that the court could do.
Okay.
Because it acknowledges Gooder and Morningstar. And I'd also point out in Morningstar, why the court said that you can change the consecutive concurrent to consecutive in Morningstar was because there was no statute saying you couldn't do this. Here we have a statute saying you can't do this.
No, the statute says you have to serve that hard 25 first. It doesn't say it cannot be a sentencing done consecutively, does it? Isn't that the question?
It says that, but it has to mean something else. Think of it this way.
But you're relying on the dictionary definition of consecutive to mean follows, correct?
Yes,
that's the piece that's not in the statute.
Yes.
And then there's another dictionary definition, Black's Law, that says consecutive sentence are, quote, 2 or more sentences of jail time to be served in sequence, end quote. It says nothing about following one or the other. It says in sequence. So my question is, in light of that, what are you relying on to say that the judge could not have made the hard 25 consecutive to these other two sentences?
I think we need to go back to your alternate definition. It's describing how two sentences are running. We're talking here about whether if what the statute addresses is ordering them to run consecutively. So if we're ordering them to run consecutively, that's different than whether they're just consecutive in general. Think of it this, and this is what I was starting to say. The Quested situation. In Quested, we had, I can't remember the other county, but the district court was wanting to impose a new sentence consecutive to pre-existing Saline County cases. I remember Saline County as the second part. So if we have, you're already serving, by definition, these on-grid sentences, which here, Mr. Warren is was serving, he was still serving a sentence at the time on these legally imposed sentences, these on-grid sentences. There's no question. I mean, he's in prison. So you're now doing something, adding on to this. You're changing this now to become consecutive. You're necessarily making that off-grid consecutive to the on-grid, which is exactly what the state is saying the district court's wanting to do, is to make it consecutive to the other.
And at the time he was serving the off-grid
The
Hard
on-grid.
50, right?
He was serving the hard 50.
Yeah, but that sentence was vacated.
I understand, but he was serving. I understood your argument to say that it's a modification from what he was doing because he was already serving the off-grid, and so first.
Yeah.
And so you're
Well,
saying
concurrently.
that the attempt to make the off-grid consecutive to would mean that he would have to go back to prison serving his on-grid first, and isn't that what you're saying
Yes.
is the modification?
Yes. The original sentence was everything concurrent. So it's kind of, to say that he was serving his hard 50 off-grid, he was serving everything at the same time. Because it was all
by
definition.
statute, he has to serve the off-grid first.
If they're consecutive, yes.
Okay.
Yeah. And with respect, I kind of, since we're down to the wire here, I just wanted to come back to your last question. Was it a change in sentence?
Yeah.
Whether a sentence is concurrent or consecutive is part of that sentence. I don't see how you can say it's not part of that sentence. Certainly, Apprendi would come into play if you were to change, if a requirement was made. It's certainly an increase in punishment for something to be run consecutive versus whether or not it was concurrent. It's certainly an increase in punishment, and your sentence is your punishment. So I don't see how you can say that it's changing from concurrent to consecutive is not a change in punishment and therefore a change in sentence.
Where did the district judge go wrong in relying on Morningstar? Because isn't essentially what happened in Morningstar what the judge did here? There was a hard 25 sentence in Morningstar for Jessica's Law conviction that got vacated, as you said, because of a lien or SOTO. Went back, and then he, in this case, he resentenced on grid. And then there's language in Morningstar that says the district court did not err when it ordered the rape sentence to run consecutive to Morningstar's other sentences.
Well, the big difference in Morningstar, the rape changed from an off-grid to an on-grid.
Right?
And in doing so, I believe it was an aggravated, the old primary crime, I believe he had a rape and then aggravated ag battery and some other stuff.
Right.
And the old ag battery was a primary crime, which carried his criminal history.
Right.
So when the rape changed into an on-grid, it became a severity level 1, greater severity level than the aggravated battery, which is at most a 4. So therefore, that rape became the primary crime.
Right.
And the court said, well, you can't make that rape now an I, because it's got to be the primary crime. And the aggravated battery can't stay as C or whatever his criminal history was, because we only apply criminal history to the primary crime. The aggravated battery's got to become an I. So necessarily, resentencing is required on both the rape and the aggravated battery. Whereas Gooder, you go back to that situation, you were dealing with, it was a McAdam case.
Before you go on to Gooder, how is what you just described about Morningstar fundamentally different from what happened here?
Because here, we never change from an off-grid to an on-grid. The primary crime is still, I believe it was the second-degree murder.
But
they're both the severity level 1s.
But the second issue that Justice Rosen was talking about is why was, on resentencing in this case, making the base crime consecutive not okay, according to your argument, but it was okay in Morningstar. That's what I'm trying to get to.
Because the statute, the court said there was no if you're talking about, because in that, first of all, I think we need to look at.
Counselor, your answer is that the vacated sentence was not the base. sentence when
Yeah.
it went back. It remained an off-grid, and by statutory provision, an off-grid could not be a base.
Exactly.
And so, in effect, this case, whereas Morningstar effectively, legally vacated all of those sentences, because when you vacated or changed the off-grid to on-grid, by necessity, you had to vacate the other on-grids because they couldn't be charged the criminal history. So it effectively vacated those. Here, there was no vacation of the on-grids because they could stay the same legally, right?
And I'm shooting myself in the foot by saying that's, just in candor to the court, in Morningstar, everything's right about that except only the ag battery was changed, not the other miscellaneous stuff in Morningstar. And they didn't make everything consecutive in Morningstar. It was just the ag battery and the rape. So you ended up with like a 240-month sentence, not a 300-some-odd month from everything else.
But the reason they went back to the ag battery was just what...
Exactly.
Justice Johnson
That is, if we're only looking at those two if we ignore everything else, that's exactly, Justice Johnson's point is exactly right. I just didn't want the court to think that it affected a bunch of other things. Didn't want to mislead anyone there. Which again, probably shooting myself in the foot.
Any more questions? Any further presentation?
There you go.
Thank you, counsel.
Mr. Chief Justice, Associate Justices, Counsel, may it please the Court. Daniel Obermeyer on behalf of the State of Kansas, Wyandotte County District Attorney's Office. Your Honor, the issue in this case is solely whether KSA 214720B5 prohibits a district court from resentencing on all counts when only one count of a sentence is vacated. For that reason, the state submits that Gooter was wrongly decided and that the court should revisit that decision and give full effect to the common law authority which this court established in Woodbury. The court should do so for three reasons. First, in Gooter, parties should have been given the opportunity to brief 214720 so that the court would have the full benefit of the parties' input as to what that actually entailed, what the intent of the legislature was when it enacted that statute. Second, because the court misstated the law in Gooter when it said in 2009 that the 1993 Kansas Sentencing Guidelines Act abrogated the common law authority of the states, it should reconsider that proposition as well. I would direct the court for that proposition to KSA 70.
Explain that. What was wrong with that?
The court in Gooter essentially said that the Kansas Sentencing Guidelines Act 214720 abrogated the common law authority which this court established in Woodbury, namely when one count of a sentence is vacated, the district court, when it's remanded for sentencing, has the authority to resentence on all previously imposed counts, whether or not those sentences were explicitly vacated by the court. And the common law was, and what 77109 says this court has to follow, since there's no statutory provision on point, is that the district court is supposed to pronounce the full measure of the weight of the punishment. And that makes complete sense from a very practical point of view, because we're pronouncing sentence for the entire case, not just for one count. When Justice Nuss called this case just now, he wasn't calling count 1 of State v. Warren, he was calling the entire case. So we're dealing with that.
And that makes sense when you're talking about the initial sentencing. But what we have here is we have a decision on appeal, and we have one sentence vacated, and we have a mandate that goes back to the district court. And we have case law that says once it goes back to the district court, all the district court has jurisdiction to do is to follow the mandate. And here we have um, two sentences that were not vacated that the judge is changing, and not just consecutive, but went from 175 months each to 150 months each, right?
I believe it was 155 months to 150 each.
Okay, well, anyway, he changed the number of months on those two, and which had to be a departure, right? Or at least modified those. And my question is, how did he have authority under our mandate rule to do that?
Well, the mandate, as it reads in Warren, was the case is remanded for sentencing. Although only the hard 50 was explicitly vacated, the case itself was remanded. And that's what I mean when I'm trying to say that the entirety of the case, the full pronouncement of the judgment against the defendant, should be pronounced by the court.
Except that didn't the decision of the court only vacate the one sentence? It did not vacate the remaining parts of the sentence.
I would say that impliedly, the argument could be made that you remanded the entire case for resentencing.
I don't think you can imply words into a court mandate. I think it's whatever the court mandated.
Well, the
And
mandate was that the case, I'm sorry, I'm just
But
reading.
the order, the last order, the court mandates based on the decision, and the decision vacated one part of the sentence.
I'll agree with that, Your Honor. I think that that's why it's important this court recognizes that Woodbury is still the common law rule. It's still in effect. We need to explicitly recognize that today because there's some confusion about that. I'd like to direct the court's attention. I put in the state's brief the legislative intent of 214720, and I think that that actually does carry a lot of weight because it doesn't divest the district courts of any authority. As I read that, it just explains to the district court what it's supposed to do when the primary count of conviction is reversed, and that's you have to afford the next highest count, the full criminal history score. It's as simple as that. It doesn't say you can't do anything else when a sentence is vacated.
What was your third reason?
Yeah, we stopped you before you got there.
Yeah, I stopped you before you got to your third reason.
Excuse me. Yeah, I sort of slid into it while I was answering your question, Justice Johnson. That would be that the common law authority of 2147, or the common law in Woodbury, was not abrogated by that legislative amendment. So I would just reemphasize that fact right there. When we're looking at the court's decision in Snow, I mean, it rightly uses the language in Woodbury that you have to pronounce the full effect of the sentence on a defendant. When a sentencing judge is looking at sentencing a defendant, he's not just looking at the primary count, he's looking at the total effect that all of those counts will have on the defendant. That involves a great deal of discretion, and that's not divested when this court remands it for sentencing.
You're saying that a sentence is indivisible. So vacate any part of a sentence and effectively you've vacated the whole sentence because it's indivisible. Because the district court judge is considering the sentence as a whole, not in pieces.
I think that's the proposition that Woodbury stands for, Your Honor. So you can either explicitly vacate one sentence and remand for one sentence only if that's the mandate, or you can remand the whole case for sentencing and let the district court pronounce the full weight of the sentences for that.
I'm sorry, were you still answering Justice Deagle's question?
No, Your Honor. Go ahead.
What do we do with counsel's argument that Gooder's been on the books for 5 years now and the legislature has not changed its holding or its rationale, and I'm not even sure if they've attempted to. Could you address that argument?
Well, 214720 was on the books for 12 years before this court addressed it in Gooder. So, and that was with the legislative amendment I'm talking about. That's not even taking into account when it was first enacted in 1993.
But we have to wait for a case. The legislature doesn't have to wait for a case to be brought. They can alter the law in response to one of our decisions anytime they want to.
Well, that's true, Your Honor, but you said that the intent, in Gooder, you said that the intent of the legislature was specifically this. I don't think that the parties had the chance to brief that in Guter to fully bring out what the intent of the legislature was for that specific statute. So now that we are considering that, this is the court's opportunity to reanalyze whether or not Guter should have been decided the way that it was.
But counsel's argument is the legislature's had 5 years to look at this and apparently has not done anything with it. So how do you respond to that?
Well, I don't have any, I can't account personally for what the legislature chooses to do or not to do, Your Honor. It could be that this is a scenario where they just aren't aware, I don't know. But I think that in the totality of the Kansas sentencing guideline, that they did not intend to divest the court of any of its discretion authority. And I would direct this court. I mentioned it, I cited it in my brief, and counsel also cited it, State v. Quested, where this court has a very excellent analysis of the legislative intent of for the Kansas sentencing guidelines. And it goes, and the language that you use in that, the legislature must give guidance to the courts by establishing the public policy and perimeters to become too restrictive on a sentence to the characteristics of an individual case or substantial justices will incur. And I think that's what happens here. It's not the court, when looking at what the legislature does, can't hamstring the court or can't hamstring the district courts because the legislature wasn't as specific as we would like it to be at this level. I think that, and it also cites some of the Senate Judiciary Committee notes on the Kansas Sentencing Guidelines that Quested does, and says that the committee recognizes that the guidelines are designed to regulate judicial discretion, not eliminate it. What the court did in Guter when it made its decision that essentially abrogating Woodbury, it eliminated the district court's decision. How is a district court supposed to pronounce a just sentence for premeditated first-degree murder and intentional second-degree murder if it can't take those other and
In this case, he had 50 years. The hard 50 was overturned because it wasn't done with jury findings, sent back, and there was another route. He could have ended up with 50 years if you would have impaneled a jury and presented and had the findings or attempted that. And here they were circumventing the direct route to get back to the 50 years indirectly by modifying the rest of the sentences. And so when you're talking about punishment fitting the crime, there was a means that was straightforward and obviously statutory that could have been followed. So I'm not understanding that from an equity or a policy standpoint, why we let shortcuts.
I think I can address your argument. I think that it is a very equitable argument, equitable to the state, that when the court imposed this sentence, when Judge Burns imposed the hard 50 sentence with the 155 months running concurrent to each other and concurrent to that, he was really just looking at the hard 50 sentence. And in his mind, I think anyone can reasonably infer, although obviously the record doesn't reflect this, that this person is going to be in prison for 50 years to life. If he had changed that, if he had run them all consecutive, then there's the argument that this is a vindictive move on the part of the court. I think in part to head that off, he thought that 50 years was appropriate, and I think that Judge Clapper on resentencing said, well, this as close to 50 as we can get, that's appropriate, because it's commiserate with the gravity of 2 human lives being taken and another one almost being taken.
What does that have to do with answering the question Justice Johnson posed about why not impanel a second jury and ask for the hard 50? Because this was just an easier way to do it and get to the same result, hopefully.
It's an easier and an equally correct way, I would argue.
It's a more certain way, in your view, correct? Because you're not subject to the whim or caprice of what the jury might do.
And
Is that why it was chosen?
I can't speak to why council chose this route, but I do think that Ms. Lickey was absolutely correct to cite Morningstar for the proposition that the district court could do on resentencing effectively what it did. I think that that was an incredibly reasonable reading of Morningstar if we're applying these principles of equity.
And what particular part of Morningstar is relied upon to do what Judge Clapper did?
To run the sentences consecutive to each other, although that they weren't affected. And counsel's right, Morningstar only addressed the off-grid sentence becoming an on-grid sentence and then running that consecutive to another sentence. But I think that that principle would apply equally if there were 2 or 3 counts, because you have a fundamental change in the base, the controlling sentence, the one that the judge is looking at initially when imposing sentence at first blush.
But that's not the base sentence. Off-grid cannot be a base sentence. When you use that term of art, the base sentence did not change. Unlike Morningstar, where the base sentence, you will agree, in Morningstar, the base sentence changed. And that meant the criminal history was applied to the new base sentence. And the other sentences, like Domino's, the ag battery or whatever, could not then have the full criminal history. So by necessity, the decision required a modification.
Correct, Your Honor, and I'm sorry.
And here, would you agree that the ruling that the hard 50 was unconstitutional did not impact the other 2? That they could have legally been left intact, would not have violated any statutory provision regarding the application of criminal history or anything else? You would agree with that?
Yes, Your Honor.
And why isn't that a huge distinction?
That they could have been legally left intact?
That they could have in this case, but they couldn't have in Morningstar. It was legally impossible not to modify the rape and ag battery.
Well, as Your Honor pointed out, that changed the base sentence, and I'm sorry I misspoke earlier in referring to the hard 50 as that. So you had to, of necessity, change it in the Morningstar case, but of necessity, you didn't necessarily have to change count 1, let's say, the rape, from a concurrent to a consecutive sentence. So that's the proposition that I think Morningstar is very important, that I think the district court correctly applied that principle.
That's what I was trying to get to earlier.
And I would agree with Your Honor in that analysis. I see that I'm out of time. If I may briefly conclude.
Your time is our time. You're out of time. Can you wrap up in 60 seconds?
Yes, Your Honor.
All right.
Under the Gouda rule, if we're to take that as solid law today, then what the district courts will be faced with and what I will be advocating for is that they should always run sentences consecutively, regardless of the weight of the offense, because we don't know what's going to happen on appeal. We don't know if one sentence is going to be vacated and if we'll be able to do anything about that. So it's best to have as large a sentence out at front, regardless of the gravity of the crime.
Why is that? Why is as large a sentence the best? I don't understand that.
To run them consecutively, I mean, in order to avoid this issue of running, due to judicial discretion, running 2 sentences concurrently.
Okay. Go ahead. Yeah.
Just the premise that always the longest possible sentence is the just sentence is what you're saying?
That's what Gouda is incentivizing, and that's what I don't think is right. I do not think that that's right, Your Honor. I think that there are lots of circumstances where it makes a lot of sense to run sentences concurrently, but if I don't know that my sentence is going to, if the defendant's sentence is going to be solid, then I'm going to ask them to be run consecutively. Or if at least the judge won't have, if a sentence is vacated, if they won't have the discretion to reassess it later. And so I would merely ask that this court explicitly overrule the central holding in Gouda and affirm the ruling of the district court. Thank you, Your Honors.
Do we have any more questions? Thank you, counsel.
As always, at my peril. I think first, the consecutive always scenario, I think, is something that I think is unlikely to happen. All kinds of reasons, just in practicality. I'm pretty sure there might be a sentencing commission issue with problem of prison overcrowding if that was the case. In any event, I don't think that slippery slope is realistic. Moving back to Morningstar and Justice Nuss's question, which the state purported to clarify. The state said the question was whether, what was the problem with the district court changing to consecutive. And I never said there was any problem with the district court doing that. That's something statutorily is okay. A non-grid can be consecutive to a non-grid. In Morningstar, that rape sentence was vacated. And as I mentioned to Justice Rosen, that sentence included whether it's consecutive or concurrent. So when that sentence is vacated and you go back, the district court it doesn't have to, but it could sentence that rape conviction consecutively to the aggravated battery conviction. And that's all we're talking about.
On-grid rape.
Yeah, the on-grid.
Because they're both on-grid.
Exactly, because they're both on-grid. I think I may have accidentally said non-grid. I meant on-grid. This is a different scenario because we're dealing with off-grid, as we've already hashed out. Moving backwards, the state argued that in equity, this didn't matter, it's all a wash. Well, it's not. The state had the chance to impanel the jury and present all the facts that it originally presented to Judge Burns when Judge Burns made those factual findings. Big difference here, it wasn't Judge Burns at the resentencing, it was Judge Clapper. Judge Clapper did not try the case. I don't believe he did, and he did not have the original hard 50 arguments made. So, and the only way we get to the hard 50 is if we get those factors. So the state was relieved of its burden of proving those factors, yet it was still able to get to that same place. And as we know, when you bring a jury into the equation, it is not the same as a judge being in the equation. Anything can happen with juries. That's why civil cases settle. People don't want to roll the dice. The state didn't want to roll the dice or go to the expense, whatever reason, and tried to get around this. And it chose an improper way of doing so under the case law. The state also, with respect to the legislative acquiescence by not changing anything after Gooter, I think the court is well aware that when the Attorney General's office has a case come down from this court that it doesn't like, it's not afraid to go over to the legislature, and the legislature is not afraid to do exactly what the Attorney General's office wants. This is something that could have been done by the legislature in the last 5 years and simply hasn't, and the doctrine of legislative acquiescence certainly should apply in this case. I think I've about covered everything that the state brought up, unless there's something that I missed that the court would like to ask me about. I have no further presentation otherwise.
Any more questions? All right, thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time.